Number one biggest issue I see are unfunded trusts. People go through the time and effort and then don't put the assets in the trust. I could not agree more with this comment. So funding a trust is just like what he said in the second part of this comment. It is actually making sure the assets get into the trust. And in fact, I have had so many people come to my office who had estate planning documents prepared at some point, and they come in thinking they're going to meet with me for a trust administration. That's where you distribute the assets out of the trust after someone passes away, or do whatever, follow whatever the trust instructions are after the creator of the trust passes away. And we come to find out that nothing is actually owned by the trust. So I actually have started looking into this a lot in my practice, and I have found out that an overwhelmingly large number of people believe that just creating the trust document itself, especially when you actually name specific assets in the trust, or if you list them on a schedule, they think that that's all that needs to be done. And then their assets are covered under the trust and everything can pass to their beneficiaries free of probate in a quicker, more stress-free manner. Unfortunately, it's not that easy. So simply naming assets in a trust or listing them on a schedule does not mean those assets are in the trust. You always have to take the second step of either retitling the asset into a trust. As an example, you have a brokerage account. So it'd be like a stock account or a non-retirement type account. You can actually retitle that account from your name individually, or if it's a joint account, from you and your spouse's name into the name of the trust. That's what makes it actually come under the trust in order to avoid probate, not just naming it in your trust. Or you have the option of potentially naming your trust as a beneficiary or POD on an asset. So life insurance, as example, you can list your trust as a beneficiary to life insurance if you don't actually own the life insurance under the name of the trust. Bank account, you can list your trust as a POD, payable on death recipient. That's how you can get the funds to flow into the trust after you pass away. Property, of course, can be put directly into the trust, or oftentimes in Florida, as you've heard me talk about a bunch, we use ladybird deeds so that a property can be owned by its original owners during their lifetime, and then again go into the trust in a TOD, transfer on death type manner after they pass away. So there's all sorts of ways that you can move assets into a trust. Even like with businesses, you can assign your interest to the trust. But whether it's an assignment or a transfer, or retitling, a POD, a beneficiary designation, however you're going to do it, the point is you have to do it. If you don't do it and don't do what's right for that asset, the trust doesn't come into play at all. Ownership never gets transferred to the trust, and the assets never get controlled by the trust. So they do end up having to go through probate. And it's one of the worst things to have to tell someone who invested a lot of time and energy and money in putting together this beautiful trust document that nothing is actually in the trust. And it's an even worse scenario to have to tell that to beneficiaries, who then you have to let them know they got to pay for a probate. And they thought, oh my gosh, my parents did all this, so I didn't have to do that. And surprise, you have to do it anyway. To avoid this, in our office, we actually offer a lot of upfront guidance, starting with the first consultation on the various steps involved in creating and making your trust work for you. So we have funding as a step where we actually offer assistance. And if our office isn't going to be hired to do the funding for you, then we do provide an asset chart based off of assets that are given to us from the client, and on the chart we make our recommendations. We basically tell the client exactly what they need to do with each asset to ensure it actually does end up in their trust, either during their lifetime or upon their passing. I think this is such an important point and really should be included in any planning, because it cannot be driven home enough how important it is to do this phase, the funding phase, moving the assets over. If it's not done, again, it's all for lost. So yeah, couldn't agree more. If anyone has any questions regarding funding or our office helps with funding. And if you're in Florida and you want to talk to us about estate planning or elder law or probate, asset protection, please don't hesitate to reach out. We are atCAUSE Law Office, the non-stuffy attorneys, and the link is in my bio.